Can I register an ordinary phrase for a trademark? That's the question I'm going to answer today. I'm Angela Langlotz, trademark and copyright attorney, and I go here live on weekdays to talk about copyright and trademark law. So today I want to talk about ordinary phrases as trademarks. Now, I come across all kinds of case studies, and today we're going to do a case study about this guy. Kawhi Leonard, I think that's how you pronounce his name. I don't really follow basketball, so forgive me if I just messed that up. But he just filed last month a trademark application for the phrase, "What it do, baby?" And I guess that's something funny that he said during a game. And so he thought, well, wouldn't it be cool to have a registered trademark for some goods with the "What it do, baby" word phrase mark on it? And yes, you can absolutely do that. And we're going to look at his application in a second. But the general rule is that anything that serves to distinguish your goods and services from somebody else's goods and services can serve as a trademark. Of course, absent some other considerations like descriptiveness or genericness or, that sort of thing. But anything can serve as a trademark so long as it's distinctive. So let's go have a look at his trademark application. It is over here. I'm just going to switch up the window. All right, so here's his application. Now, he has applied for "What it do, baby" for certain goods. The goods that he's going to use it on are clothing. So athletic and athletically inspired clothing. All right. Now, he hasn't started using it yet. How do we know? Well, because right down here under basis, it says 1B. What is 1B? That is an intent to use trademark application, meaning that he's not using it on any clothing just yet, but he intends to do so in the future. And so here's the applicant's name here and the address that he's using and his attorney of record. So what can we learn from this trademark? Well, we can learn what the goods are, right? So we can learn exactly what he's applying to use it on. And we know when the filing date was. It was October, so it was the month before last, not last month. And then we know that he's not using it yet because of this 1B application status. And so what does that mean too? It also means that later he's going to have to prove use of that mark on clothing at some point in order to get a trademark registration. So remember that trademarks don't happen in a vacuum. They have to be applied to goods or services and used with the goods or services in order to have trademark rights. So, and we have to show that trademark use to the United States Patent and Trademark Office by submitting a sample. It's called a specimen, a sample of how we're actually using it on the goods claimed in the application. So we'll have to see what happens with this application. Whether he actually produces the clothing line or not is kind of an interesting question. But yes, the short answer is you can use an ordinary phrase as a trademark. I'm Angela Langlotz, and I go live here on weekdays to talk about trademark law. You can find me online at trademarkdoctor.net and also on Facebook at facebook.com/trademarkdoctor. I also have a YouTube channel that has oodles of good trademark information on it. And if you go to YouTube and search Trademark Doctor, you will find me there. Subscribe to my channel and you'll be notified every time I go live.